3, 2, 1, start. Gurvinder Kaur, then plaintiff, now respondent, filed against Mahabir Singh and another present petitioners a suit for declaration that she is co-sharer, co-owner of the land duly described and deposited in the head note of the plaint on the basis of being a co-purchaser of the extent of 1 by third share and has sought to challenge the transfer deed number 5313 dated 14 March 2008 alleged to have been executed by Mahabir Singh being illegal, null and void, and sought consequential relief of permanent injunction restraining the defendant from further lightening the suit land stop. During the course of trial of the suit, an application under Order 6, Rule 17 CPC was moved by the defendant that due to inadvertence it has been mentioned in the written statement that the suit land is a central joint Hindu family property and thus acceding to the plea of the plaintiff when in fact the property has devolved upon defendant number 1 through testamentary succession and therefore wanted to amend the written statement. Stop. The same stood declined wide impugned order dated 13 May 2014 by the Court of Additional Civil Judge Senior Division Malot, and that is how the present revision petition has come about. Stop. Appreciating the submissions of the two sides, it is the plea of then applicant, present respondent, that the will was executed on 4 July 1997 by deceased Gurmej Singh, father of Mahabir Singh, and thus it was his personal property, and the plea so taken in the written statement thus needs to be amended. Stop para. The parties are litigating over an estate of the family. Stop. The will is claimed to be dated 4 July 1997 and the suit has been filed in the year 2014 and by that analogy, the will was very much in existence at the time when the written statement was filed, and apparently because of inadvertence by the counsel of same could not be raised and is purely an error by the counsel who had drafted the written reply on behalf of the party. Stop. More so, for comprehensive adjudication of the dispute between the daughter-in-law and the father-in-law, it is necessitated that such a plea may be allowed to be raised so that it could be judicially adjudicated at this juncture when the suit is underway, and to the similar proposition is a single bench view of this court in Charan Kaur and another versus Pritam Singh and others. Stop. The apex court in Usha, Bala Sahib Swami and others versus Kiran Apaso Swami and others, while interpreting the law on this issue, has held that amendment is written statement needs to be taken in a liberal manner, and that a party is within his right to amend even contradictory stand earlier taken in his pleadings, and thus allowing such a plea would be conducive to the once and for all statement of the dispute between the parties through adjudication by a court of law. Stop.